There is a legal protection written into the law of almost every state in America that makes a portion of the equity in your primary home completely untouchable by creditors. Not difficult to reach, not subject to additional legal process, untouchable. A judgment creditor who wins a lawsuit against you, a medical creditor who claims you owe $100,000, a business creditor who pursued you personally after your company failed. None of them can force the sale of your home to satisfy the judgment up to the protected amount. In Texas, that amount is unlimited. In Florida, it is also unlimited for a home of any value on a property of up to half an acre in a municipality or 160 acres outside one. In Massachusetts, it is $500,000. In California, it is between $300,000 and $600,000, depending on the county median home price. In states with lower exemption amounts like Virginia at $25,000, the protection is more modest, but the protection exists in every state for every qualifying homeowner. The provision is called the Homestead Exemption. It traces back to the Republic of Texas in 1839, a full 7 years before Texas joined the United States, when the Texas Congress passed what historians of American property law describe as the first homestead protection statute in the Western Hemisphere. The law was enacted to attract settlers to the Republic by guaranteeing that a family's home and a defined amount of land could not be seized by creditors, regardless of the settlers' debts. The concept spread across the United States through the second half of the 19th century, and today, no state in America lacks some form of homestead protection. And yet, according to research compiled by legal aid organizations and state assessor offices, roughly 60% of homeowners who are eligible for homestead exemptions in states that require registration have never filed the necessary form. They are unprotected, not because the law does not cover them, because they never filed the paperwork. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The homestead exemption operates in two distinct legal contexts, and understanding both is critical. The first context is creditor protection. In states with homestead exemption statutes, a judgment creditor who has won a civil lawsuit and obtained a judgment against you cannot force the sale of your homesteaded primary residence to satisfy the judgment up to the exempt amount. If your home is worth $300,000 and you have $200,000 in equity, and your state protects $500,000 in equity, your home is entirely protected. The creditor can place a lien on your property but cannot force you to sell. The lien attaches to the property but remains subordinate to the homestead interest, and typically cannot be executed until you voluntarily sell, at which point the creditor's lien may or may not be satisfied, depending on the equity remaining above the exemption. The second context is bankruptcy. The federal bankruptcy exemption system allows debtors to protect certain assets from the bankruptcy estate under Section 522 of the Bankruptcy Code. States can opt out of the federal exemption system and require debtors to use the state exemptions instead, and most states have done so. When a debtor files for bankruptcy protection, the homestead exemption in their state determines how much home equity is protected from the bankruptcy trustee. In states like Texas and Florida, the unlimited homestead exemption means that even a multi-million-dollar home can be retained through a personal bankruptcy, as long as the homestead requirements are met. This is why some wealthy individuals facing financial distress choose to move to Texas or Florida before filing for bankruptcy. The 2005 Bankruptcy Abuse Prevention and Consumer Protection Act added a limitation to prevent abuse of unlimited state homestead exemptions in bankruptcy. Under BAPCPA, a debtor who acquired their homestead within the 40-month period before filing for bankruptcy is limited to a federal homestead exemption of $225,000, regardless of their state's unlimited exemption, if the homestead was acquired with proceeds of fraud or certain other misconduct. The limitation also applies in the calculation of means testing, but for homeowners who established their primary residence in Texas or Florida years before any financial crisis, the unlimited protection remains fully available. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete state-by-state homestead exemption chart, including exemption amounts, registration requirements, acreage limits, and bankruptcy application rules, the Homestead Declaration Filing Guide for states that require registration, the Bankruptcy Homestead Strategy Analysis, and the Property Transfer Trap Guide, showing how transferring property into certain trust structures can affect homestead qualification. The link is in the description, but stay right here. The registration requirement is where millions of eligible homeowners fall through the protective net. States fall into two categories regarding homestead protection. Automatic states are those where the homestead protection applies automatically to a qualifying primary residence without any filing requirement. Texas is the most notable example of a state where the homestead protection is automatic and unlimited. A Texas homeowner who meets the eligibility requirements, meaning the property is their primary residence and is within the size limits, is protected without filing anything. Registration states are those where the homeowner must file a declaration of homestead or a similar document with the county recorder, assessor, or clerk to activate the protection. Massachusetts is a registration state. California is effectively a registration state for purposes of maximizing the protection available. In California, the automatic homestead exemption under Code of Civil Procedure, Section 704. 730 protects between $300,000 and $600,000 in equity automatically, but the Declaration of Homestead provides additional procedural protections and was historically the primary mechanism for claiming the exemption. Virginia requires recording a homestead deed to claim the exemption. Georgia requires a homestead exemption application with the county tax commissioner to receive the property tax reduction component, though the creditor protection element works differently. The homestead exemption also provides a separate and distinct property tax benefit in most states. A homeowner who occupies their primary residence typically qualifies for a reduction in the property's assessed value for tax purposes. In California, the homeowner exemption reduces the assessed value by $7,000, saving roughly $70 to $100 per year in property taxes. In Florida, the homestead exemption reduces assessed value by up to $50,000 for ad valorem taxes and provides the Save Our Homes assessment cap, limiting annual increases in assessed value to 3% or the consumer price index, whichever is lower. In Texas, the homestead exemption reduces assessed value by $40,000 for school district taxes and provides the 10% annual assessment cap for all other taxing entities. These tax savings compound over time and are entirely separate from the creditor protection benefit. If you have made it this far, you already understand the homestead exemption at a level that most homeowners who are currently unprotected never reach until after a creditor has already filed a lien. Subscribe and share this video. Now let me give you the exact steps. Step 1. Determine whether your state requires registration of the homestead exemption or whether it is automatic. Your county assessor's or recorder's office can confirm this, and many counties have this information on their websites. Step 2. If your state requires registration, obtain the applicable form. In Massachusetts, this is the Declaration of Homestead under Massachusetts General Laws, Chapter 188. In California, the Declaration of Homestead is recorded with the county recorder's office. The forms are typically available from the county recorder, from legal document preparation services, or from an attorney. Step 3. Complete the form with the required information, including your name, the property address, the legal description of the property, and a statement that this is your principal residence. Step 4. Have the form notarized if required. Most homestead declarations require notarization as a condition of recording. Step 5. Record the form with the appropriate county office, typically the county recorder or register of deeds. The recording fee is typically between $15 and $50. This is the only cost of activating potentially hundreds of thousands of dollars in protection. Step 6. Verify that the recording was completed by obtaining a stamped copy or a recording confirmation number. Keep this documentation with your important financial and legal papers. I need to be honest with you. The homestead exemption has real limitations that vary by state and situation. First, the homestead exemption does not protect against all creditors. Mortgage lenders, property tax authorities, homeowners associations, and, in some states, mechanics lien holders can still force the sale of a homesteaded property despite the exemption. The protection runs against general judgment creditors, and in bankruptcy proceedings, not against secured lenders who have a legitimate lien on the property. Second, in states with lower exemption amounts, the protection may be less meaningful for homeowners with significant equity. If your state protects $25,000 and your home has $400,000 in equity, the exemption covers only a fraction of your exposure. Third, the property must be your primary residence. Vacation homes, rental properties, and investment properties do not qualify for homestead protection. If you move and use a former primary residence as a rental, you may lose the homestead protection on that property. Fourth, in bankruptcy, the timing rules under BAPCPA can significantly limit the availability of unlimited state exemptions for homeowners who recently acquired their property or recently moved to a new state. And fifth, transferring a homesteaded property into certain types of trusts or business entities can in some states cause the property to lose its homestead qualification, depending on whether the trust meets the state's requirements for homestead eligibility. Your great-grandparents who settled frontier land understood what it meant to have a homestead. The word itself carries the weight of survival. A place that could not be taken, a ground that could not be sold from under you. The Republic of Texas encoded that understanding into law in 1839 because the alternative, a world where families could be left without shelter because a creditor had a legal claim, was incompatible with the kind of society they were trying to build. Then one generation moved into apartments, into rental units, and eventually into homes whose protective potential they never registered, never filed, and never activated. The paperwork is one page. The recording fee is $50. The protection is potentially unlimited. There was not a more important form that was never explained to you at closing. Subscribe and share this video. Every share files the Homestead Declaration for someone who has been unprotected for years without knowing it. The next vault opens soon, and what is inside will show you exactly what the Credit Card Act of 2009 requires your bank to offer you when you are struggling to pay.